Hi, this is Josh Blackman, and I'm the president of the Harlan Institute, and it's my honor to welcome you to the 2021 Harlan Institute Virtual Supreme Court competition. This year, we're arguing the case of New York State Rifle and Pistol Club versus Bruin. We are now in the semifinal round, and this is match number 13, the last match of the semifinal round. From Lake Oswego High School in Oregon, we have Devin Von Arx and Lucia Zhang. And from Paradise Honors High School in Arizona, we have Selma Ahmed and Dan Bednarik. And they'll be arguing the New York State Rifle and Pistol case. Okay, without further ado, petitioners, you have 10 minutes whenever you're ready to begin.
Mr. Chief Justice, and may it please the court. In September 2014, Robert Nash and Brendan Koch of New York separately applied for concealed carry licenses. Both of these permits were denied under the 1911 New York Sullivan Act. The law states that an applicant must demonstrate a special need for self-protection distinguishable from that of the general community or persons engaged in the same profession in order to obtain a handgun permit. Today, we will argue that New York State's denial of the petitioner's applications for concealed carry licenses violate their Second Amendment right to keep and bear arms outside the home for self-defense. Additionally, it does not satisfy means and scrutiny, and it violates their 14th Amendment right to due process.
The operative clause in the Second Amendment guarantees two distinct rights: to keep and to bear arms. District of Columbia v. Heller concluded that keep arms was simply a common way of referring to possessing arms. In contrast, to bear is another phrase for to carry, like a coat, for purposes of confrontation and self-defense. If the framers had intended for keep and bear to refer to the same right, possessing arms in the home, they would not have included both words. Heller and McDonald v. City of Chicago reaffirms the inherent right of self-defense as central to the Second Amendment. If in the Second Amendment right is a fundamental constitutional right, not an exception or privilege that requires the subjective judgment of a government official, requiring a demonstration.
If I could jump in and interrupt you for a moment, Counselor. What exactly is the right the Second Amendment protects? Is it the right of concealed carry or right of open carry?
The right that the Second Amendment protects is to keep and bear arms, and it does not matter whether it's concealed or open carry. In this case before us, we're looking at a concealed carry. However, as long as one avenue is allowed, it will satisfy the Second Amendment.
And what sort of historical evidence do you have in support of this right of concealed carry?
Well, Your Honor, the Second Amendment, historically, there have been some restrictions. However, ever since the Heller case, there's been a new interpretation of the Second Amendment and the idea that you have an inherent right to have a weapon, whether it's concealed or not concealed, you can possess a gun.
Well, Counsel, let me ask you about a piece of evidence that's often discussed, which is the Statute of Northampton. How do you understand that statute?
The Statute of Northampton was established in 1328, which was several hundred years ago, and it was also in England. And is established in Federalist 46 by James Madison. What makes the United States unique is partially the right to carry arms, and that's different from the intentions of English law and also the motivations behind those.
Do you think, sorry to interrupt, do you think the American right is broader than the English right was?
Yes, Your
Honor. Well, oh, go ahead, Justice Carrillo. Thank you.
Well, how do you square that with the North Carolina law, which essentially adopted Northampton-style carry bans post ratification of the Second Amendment?
The North Carolina law was indeed similar to the Northampton, but as we were stating, ever since the Heller decision, the courts have really changed how they've perceived the law.
And Your Honor, also in terms of other bills of rights before the Constitution and even after the Constitution, many of the original states adopted analogies to the Second Amendment, including a right to keep and bear arms for the defense of the state, free government, or for themselves. And in some states, they even had specific language, right to bear arms in defense of himself and the state.
All right, maybe
so with that being said, what's your best piece of historical evidence?
For instance, historically, if you want to look at the precedent.
Just one, your best one.
I would say in Vermont, you had the right to keep and bear arms in defense of themselves in the state, which I think is really good because it clearly shows how the American people wanted a right for self-defense. We can carry a gun outside the home in order to defend ourselves.
Thank you. Proceed, counsel.
Additionally, New York's regulations on concealed carry violate the Second Amendment because it does not satisfy means and scrutiny. Heller explicitly eliminated rational basis review when looking at the Second Amendment, leaving intermediate and strict scrutiny. However, under both intermediate and strict scrutiny, the New York law should be overturned. Under intermediate scrutiny, it is the government's burden to prove that regulations serve an important government objective and be substantially related to achieving that objective. New York's licensing law fails on the second prong. There's been no proven causation or even correlation between the proper cause requirement and increased public safety, despite respondents' attempts.
Counsel, maybe we're getting the cart before the horse. What level of scrutiny should we be applying here?
Your Honor, in terms of the Second Amendment, we should be applying strict scrutiny because this is a fundamental enumerated constitutional right. However, as we stated, under both levels of scrutiny, this law would not satisfy.
Well, why do you think strict scrutiny should govern? I mean, did Heller establish that strict scrutiny should apply?
Heller did not establish that strict scrutiny should apply. However, we believe it should be under strict scrutiny because it is a clearly stated, defined right in the Second Amendment. The Second Amendment says you have a right to keep and bear arms, and thus it should be hard for the government to take away this right.
Well, let's just assume that we disagree with you and that intermediate scrutiny governs this case. How would the New York law shake out under intermediate scrutiny?
Yes, Your Honor. So as we're talking about, the New York law would have to be substantially related to achieving the objective of increased public safety, which it does not. And the evidence we point to is the National Research Council and Community Preventative Services Task Force, established by the U.S. Department of Health and Human Services, comprehensive reviews of the scientific literature on the effects of may issue versus shall issue regimes. These two reviews reached nearly identical conclusions. The evidence was insufficient and none of the different arguments were convincing due to inadequate sample sizes and too many confounding variables.
So let's say that the statistical evidence is, unclear, right? We don't know which way the statistics go one way or the other. Shouldn't that mean we simply defer to the elected branches? We defer to the New York government that they can make the decision. We're judges. Why? If the evidence is so, I don't really know, safe or not, why don't we just go with the government?
Your Honor, Your Honor, so basically in intermediate and strict scrutiny, it is the government's burden to demonstrate a substantial relation between their regulation and their objective.
The government's burden, it's not your burden, you're saying.
Yes, under rational basis, it would be the petitioner's burden. However, under intermediate and strict, it would be the government's, and they clearly have not done that.
Very good. Maybe continue, Counselor.
Right.
New York's licensing procedure is unconstitutionally vague. The vagueness doctrine refers to the court's recognition that due process is violated when the statute at hand is written so vaguely it would lead to arbitrary governmental actions. This precedent has been established in cases such as United States v. L. Cohen Grocery, Connolly v. General Constitution, NAACP v. Button, and Johnson v. United States. In regards to the New York law, the question is, what exactly would constitute proper cause? New York defines the term as demonstrating a special need for self-protection distinguishable from that of the general community. However, while New York courts have attempted to bring some clarity to the term, there remains many unanswered questions about what determines a special need. Bernstein v. Police Department determined that—
Let me interrupt you. I appreciate all these cases. What standard would you adopt? If we get rid of proper cause, what standard would you adopt?
Your Honor, our goal here is to eliminate the proper cause requirement completely because of the foundational understanding.
Not that. What do we replace it with? We got to replace it with something.
So for example, in Heller, we state that there can be longstanding prohibitions such as sensitive places, objective regulations such as those in the Gun Control Act, Brady Act, such as background checks, making sure you don't have
what
any
law?
felons.
Give me a law that you like in the United States. What kind of law would you favor?
I would favor something such as the Brady Act, which institutes objective standards for obtaining a license.
Is there a state law that you prefer? Because the Brady Act is a federal standard.
Yes, Your Honor. Any of the 42 shall issue regimes.
So you think the Constitution requires shall issue? That's what I was getting at.
Yes, we believe that it should be shall issue. You can have some regulations on who can carry guns, but they have to not be subjective.
Okay, and you have 30 seconds left, Council, if you want to wrap up.
Heller also says that the phrase "the people" leads to a strong presumption that the Second Amendment right is exercised individually and belongs to all Americans. For all the preceding reasons, we believe that New York State's denial of the petitioner's applications for carry licenses violates means and scrutiny and their 14th and Second Amendment rights. Thus, we pray for you to rule in favor of the petitioner. Thank you.
All right, excellent. Thank you so much.
Thank you.
Petitioners, please turn off your camera. Respondents, please come back on camera, and you'll have 15 minutes whenever you are ready. Okay.
Hi, we are ready.
Okay, Megan.
So I would like to first bring up how our opponents stated that an exception or privilege would be demonstrated and how there was no exception or demonstrated in McDonald versus Chicago because it reaffirmed it. However, in the US versus Wangji, it stated that a man who was a felon had a concealed carry arm. In that circumstance, you cannot have proper cause due to his felon state. They also stated that it does not matter to have a concealed or open carry firearm, but in the US Supreme Court, Robertson versus Baldwin, it ambiguously stated in 1897 that the Second Amendment protection does not extend to the carrying or concealed weapons, and the right of the people to keep and bear arms is not infringed. And it should also not be applying strict scrutiny based on the Second Amendment, which is stated in Kachowski versus City County of Westchester, where in some form of heightened scrutiny, it would be appropriate, but in strict scrutiny was not necessary. And instead, applying intermediate scrutiny as well as holding intermediate scrutiny is appropriate, where firearm regulation does not burden the core protection of the self-defense. I believe they apply proper cause because regulations requiring a permit to carry a concealed weapon, which is also stated in Kachowski versus County of Westchester, which hold that a New York law preventing individuals from obtaining a license to possess a concealed firearm display proper cause and did not violate the Second Amendment.
All right, so Council, let me just be there. What standard of review should we be following here? And this
We would like to go.
Yeah, good.
Sorry, do you mean as in scrutiny? What
Yeah,
we should
what
go
standard
over?
of scrutiny should we be applying here?
We would say intermediate scrutiny.
Okay, why not strict? Your friends on the other side say strict scrutiny. Why should strict
So-
scrutiny apply?
We would not go over strict scrutiny because it's not a defined, to keep and bear arms is a defined right, but it's important to know that this is simply a regulation, and regulations have been seen on the Second Amendment time and time again, simply seen through US v. Vangé, where felons are restricted.
We're not talking
to-
about felons here. We're talking about law-abiding citizens.
All right, law-abiding citizens. So even in law-abiding citizens, the background checks still stand standard to
Right, but the other
regulate.
side's okay with background checks. We're talking about the good cost standard, or proper cost standard.
In this case, when they were demonstrating proper cause, it did not show that they had an intermediate threat to their way of life. In
Well,
this
I
case,
know that. I know they didn't mean the standard, but they're saying the standard's unconstitutional. All right, my question is going to step back. Why should strict scrutiny not apply here? That are law-abiding citizens seeking to exercise a right written in the Constitution.
strict scrutiny should not apply in this case because with strict scrutiny, it is a form of judicial review that courts use, and it's often used under discrimination cases. And in this case, it's not. And with immediate scrutiny, which was
You still
created,
have, but in First Amendment cases, we apply strict scrutiny without evidence of discrimination. Why should we not use strict scrutiny here?
Well, we could look at Matter v. Moore versus Gallup, where good character and proper gun training is not enough for someone to get a gun license.
No, I'm more basic. Why should we not use? What did Heller say about the tier of scrutiny or the level of review? Okay, Heller said we apply heightened scrutiny, right?
Yes, Your Honor.
Heller didn't clarify which standard we use. Why do you think we should use intermediate scrutiny?
Well, they didn't want to go over strict scrutiny because otherwise it'd
Forget
be.
them, forget them. I'm asking you, why should we use intermediate scrutiny here?
to clarify, you're asking why should we use intermediate scrutiny as pertains to this case?
Yes, Counselor.
Well, with intermediate scrutiny, it is based on the statute on as well as discrimination. And in this case, it is not exactly being discriminated against the Second Amendment. And in this case, as we have stated before, the proper cause that they have shown is that they were essentially going to use their guns for hunting as well as target practice. And with strict scrutiny, it did not happen to be a form of judicial review that they had to use with a plot violated the Second Amendment fully.
All right, counsel, you can proceed with your argument.
I would also like to state that the New York State law under the Penal Law 400 constitutionally prohibits the license of a concealed gun for anyone that does not have proper cause. And the question of whether the Second Amendment allows the government to prohibit a law-abiding person from carrying handguns outside the home for self-defense does not violate the Second Amendment. And to demonstrate proper cause, as we stated, is a regulation. And one example of this was displayed in the US Mangin, where in that case, it was seen of how they had to submit an application form of owning a gun. And the common law of displaying proper cause states that the individual right to possess and carry a weapon, in this case, a confrontation, history and tradition do not support a right to keep and carry any weapon.
Let's talk common law and history and tradition just for a second. What is your best piece, your just one, your best piece of historical evidence that supports your proposition in this case, your contention in this case?
Our best piece of evidence would most likely come from the common law.
You freeze for real.
Okay. You there?
I think they froze, Professor.
Yeah, I'm gonna pause their timer. Lose their time. Are you guys back?
I think
You froze
they're
for
back.
30 seconds.
We're here.
Yes.
Yeah,
Can
so
you hear
start
us?
again.
Yes.
Your best piece of historical evidence.
Yes, so as I was saying, sorry about that. Common law would come from common law in Northampton. It was made in 1328 and it was still applied in the 18th century of England, where we would have restrictions of owning a gun against people who do not fall in the category of a higher class that would have a reason to carry a weapon to transport, for example, the king. Ordinary citizens would clearly need to have a high statute to carry their weapons around, as well as concealable weapons like handguns were restricted until the city of London would eventually even ban handguns entirely. Basically, this idea of restricting people who would have a reason and to carry a weapon is seen in the 18th century of England and colonies still today. Many of the colonies would even use these common laws from England and apply it to themselves to go as far as to restrict travel with weapon in populated areas. Eventually, the American law would start to see that some people carry firearms with good intentions, which started the idea of proper cause.
Okay. You may proceed with the argument.
And in this case, the provisions of the DC Code made it illegal to carry an unregistered firearm and prohibited the registration through the chief of police could issue 1-year license for handguns. The court in dicta stated that the firearm regulation would not implicate the Second Amendment if that weaponry cannot be used for law-abiding purposes. The record must show that the proper cause includes target practice in hunting or self-defense means of a license. The proper cause does not include the 14th Amendment because it does not discriminate or deny people's choice. And based on that and who they are, but strictly behind owning a gun, which was argued in McDonald v. Chicago. Upon further research, we are prepared to argue that the case should be in terms of intermediate scrutiny to...
Counselor, let me interrupt you. So is it the position of the respondent that the New York statute is not too strict and is what is required to meet the needs of the citizens?
So are you saying what is for the benefit of the citizens?
What I'm saying is the position that it should continue to be as strict as it is and no changes are needed.
Correct.
And how do you reconcile that with the vast majority of the states in the United States allowing people to carry firearms outside of their homes? Like, why do you think New York should be in the minority of that?
We believe New York would be in the minority of that situation in comparison because of their higher population density compared to many other cities. And overall, there could be much more damage for someone of that could cause more, basically cause more damage to a higher group of people to own a gun when they shouldn't. So that's why the proper cause should be there.
Do you have any statistics or case law to back up the facts that you think because of the high population in New York that there is a greater need?
Well, we could look at the Brandy Act when the background checks were implemented. So basically, the FBI held a standard where 32% of gun-related homicides reduced, showing that regulations on the Second Amendment do in fact reduce violence from guns.
Well, let me ask you a different question. New York is not all the city, right? There's parts of New York that are pretty rural. Would you apply a different standard in perhaps upstate New York where there's far less urban density?
To be quite frankly, to be honest, in that situation, it seems kind of a little iffy. I think it should just go towards the entire state, because obviously with like McDonald, for example, like interstate commerce, we wouldn't allow that, but through the state, they could just travel to another portion. So I think it should just stay consistent throughout the entire state of New York.
Okay. All right, you can pursue with your argument, Counselor.
And because of the standard of stricter scrutiny, it should be avoided if possible to hold a true decision of the court in terms of the Second Amendment, as it is meant for protection of the people, but also the destruction of people when not regulated or restricted in particular cases. This is because there's a reason for the Second Amendment to be regulated for the safety of the citizens. In New York, as we had previously stated, there's a denser population, which requires more regulation on weapons to prevent mass shootings and crowds. As depicted in Kachowski, New York State Rifle Association and Pistol Association, Incorporated v. Bruin, it was holding immediate scrutiny where it was appropriate for firearm regulation does not burden the core protection of self-defense in the home, and it does not take away the self-defense. And if you're looking for an additional source to straighten that case with historical precedents, that would also be stated in, for example, Hightower v. the City of Boston. I would also like to add that Joseph's story, The Commentaries of the Constitution of the United States, he said the right of the citizens to keep and bear arms has justly been considered as the palladium of the liberties of a republic, since it offers a strong moral check against the usurpation or arbitrary power of rulers, and generally even if the success of the first instance. And essentially, with his claim, Joseph's story, he was essentially adding to the fact that we need more of a proper cause, as well as a regulation and not infringement upon the Second Amendment, in this case, the New York case.
Let me ask you just a very basic question, kind of a yes or no. Do you lose under strict scrutiny?
If that were to happen, yes.
Okay.
We yield our time.
Thank you so much, Counselor.
Thank you.
Petitioners, you have 5 minutes rebuttal.
In Your Honor, in response to the first argument, which is that in Robertson v. Baldwin, it doesn't extend to concealed carry, New York could switch to open carry. It doesn't matter to us. Really, as long as there is a way to carry a gun and to have your Second Amendment right, we are perfectly happy with that. The problem is with the New York law right now, you can't do either.
Additionally, they argue that this law should be analyzed under intermediate scrutiny, and as we proved, it does not satisfy intermediate scrutiny. So while we will not go into detail and argue, should it be strict, should it be intermediate, our main argument is that it would fail under both.
Further,
Well, so if New York turned around and said you can have open carry but not concealed carry, you'd be okay with that?
Yes, Your Honor.
yes.
Okay, good, thank you. Okay, you proceed.
Further, they cite some circuit cases like Matter v. Moore, but obviously circuit cases do not set precedent.
And we're looking towards the Supreme Court today to set precedent in regards to future gun policy and gun law.
So let's talk about death though. So I mean, guns are dangerous, right? People can die from guns. How many people have to die for you to perhaps change your mind on this case?
We believe that regulations, objective regulations, are totally understandable. We understand that guns are very dangerous weapons, and law-abiding citizens should be the only ones allowed to carry them. However, according to the Violence Policy Center, America's 18 million concealed carry permit holders accounted for 801 firearm-related homicides over a 15-year span, roughly 0.7% of all firearm-related homicides during that time. And so while we totally understand that abuse and exploitation of guns is completely a danger, it is not the one that is before us today. And proper cause is not the right way to
Right,
reduce.
but still, I mean, there is what, 800, was that the number you said, 800 something?
Yes, Your
Why don't
Honor.
we make that number 0? I mean, that's 800 lives that matter to someone, someone's mom, someone's husband, someone's wife. Why can't New York City want that number to be 0?
Well, as we stated earlier, Your Honor, there's just not enough evidence to show that the New York law actually results and reduces the number of gun violence that we have. The evidence is insufficient.
But the evidence isn't conclusive. Why don't we simply defer to the state?
Your Honor, because as we stated under these levels of scrutiny, not excluding rational basis, which Heller eliminated, it's the government's burden before they can implement a regulation to satisfy that level of scrutiny. And they haven't done so. And so while other regulations such as the Brady Act would be constitutional, the proper cause one is ineffective and unconstitutional.
Okay, thank you, Councilor. You may proceed.
Further, our opposition said that it doesn't violate the 14th Amendment. However, as we already stated, it does violate due process and the vagueness doctrine. What constitutes proper clause is not clearly defined in the law. And then the Statute of Northampton, they said was their best argument and the best historical precedent. But as we mentioned, the Statute of Northampton was made in 1328. The Games Act of 1671, which was also in England, said the right to have a gun was limited to people who have a freehold of at least 100 pounds a year. Clearly, old historical English law is not something that should matter right now. We want to get the most recent interpretations of the Second Amendment, which was done under Heller.
But how long has the New York law been on the books for?
Since 1911.
So, I mean, over 100 years, right? None of us
Yes.
were alive in 1911, I don't think. When did this law become unconstitutional? It's been unconstitutional for 100 years and no one knew it?
I think, Your Honor, the key here is that our understanding of our rights continually change. For example, the right to privacy was not really a right until Griswold v. Connecticut and the cases after that, such as, abortion, Roe v. Wade, things like that. And so when we look at this right, the Second Amendment right, our interpretation of the right can change. It's not about pinpointing an exact time in which it became unconstitutional. It's just when our understandings shift, so they conflicted with each other.
Excellent. You have about 30 seconds left, Council. If you want to wrap up, you can.
Yes. So Heller also states the phrase that the people leads to a strong presumption that the Second Amendment right is exercised individually and belongs to all Americans. Considering that New York Attorney General James stated that only around 65% of the applications for an unrestricted permit in New York receive one, it's clear that the subjective licensing procedure exposes a particular danger to unequal application made possible by the vagueness in the law. Thus, we pray for you to rule in favor of the petitioner, and thank you so much.
Excellent. Thank you so much. Great job. If the response can come back on camera, please. I'm very proud of each and every one of you. That was not easy. The questions we're asking were really hard. And we were putting you through the same sort of pressure that we would put a first-year law student through, and you rose to the occasions. That was very, very impressive. You had command of history. You had command of the text. You had composure. When I threw these very hard questions about you about dead bodies and things, you didn't flinch. You sort of just, you carried on. You pivoted from your weakness to your strength, right? I gave you a question that was not in your favor, and you switched from weakness to strength, and that was very good. And a couple occasions, both teams, we asked you a question and you didn't know. And that's okay, right? You don't expect to know everything. And maybe the judge is mistaken. So you say, Your Honor, I don't know, or I haven't thought about that before. That's a perfectly fine answer. It's better to say, I don't know, than to make up something on the fly and get killed for it. Also, a couple points you said, you conceded points that are not in your favor. Like, do you lose under strict scrutiny? Yes, smart, because you're not gonna win that one. Other teams have tried to argue and they just lose. So you make a strategic decision to concede certain points, but not concede others, which was very strong. I'll just give some feedback in a minute, but I want to make sure Ashley and Reed have a chance to jump in first.
I thought y'all did really good. I like that y'all conceded the point, and I also thought y'all gave really good thought out answers to the questions. And overall, I think y'all did really good.
Yeah, so I thought everyone did a really good job of respecting the court's time. I don't think we saw anyone go overtime this round, which is a very pleasant thing for us. I thought everyone had appropriate deference for the court. No one was rude or interrupted anyone on the bench. Good use of the phrase "Your Honor." That was great. A critique, more critiques though. Across the board, everyone slow down a little bit. Give us those pauses so we can jump in and ask you the questions because you want this to just be a conversation with the bench. I could also use over Zoom. It's already a tough platform to give an argument. That being said, uh, don't be afraid to have a little more inflection in your voice. You'll stand out a little more. But I thought another really good thing though, everyone this round I found was very responsive to the other side.
Yes, great.
So very good job overall.
Yeah, a few viewpoints. For respondents, you jumped right in. You forgot to say, "May it please the court." I think you were probably so excited to get going, you forgot the introduction. I was like, "Whoa, I didn't realize you started yet," and then sort of just jumped in. So just be careful to, no matter what happens, Your Honor, may it please the court. That's just like the first thing that's got to leave your mouth. I also appreciate that when you have 2 minutes left and you don't have anything else, I yield my time. Fine. If you made your case, you made your case. You don't need to sit here and beat a drum and they got nothing left to say. So that was actually, I think, a good move to just sort of yield your time. And then for the team from Oregon, I think you had a good command of cases. The statute of Northampton is not entirely on your side, but I think you dealt with it well, saying, look, this is an old statute. We live in a different country. You brought in Griswold, which I think was a very creative argument. First time in 2 days, someone brought up Griswold. So, you had a prize for the last case of the day, which was good, but it shows you actually know common law. And I know your teacher for many years, and he's teaching you some good stuff. I think he's somewhere on the call in silence. Do any of you have questions for us, things that we can help you with either on law school or the competition or whatever else is on your mind?
I guess I would like a kind of a general question. What's your favorite part about doing this type of work and being in this field?
Teaching. I mean, my full-time job, I'm a law professor. That's what I do. So I teach people like Ashley and Reed, but my passion is teaching. And I consider this competition teaching, right? I gave you a lesson you're not going to forget, right? This is going to be, you're going to go back on Monday, you're going to watch this on YouTube and, oh man, I should have said this. I should have said this. I should have done this, right? Trust me, you're going to do it. And you're going to remember this. And when you go to college and you go to a moot court competition or mock trial competition, you're going to remember, it's like, oh, I remember what Blackman told me a couple of years ago. And then a couple of years ago, law school, and you're going to kick butt and you're going to do really great things. That you have such great potential ahead of you to do this in high school. I could not have done this in high school. You could be law students tomorrow. You go to law school tomorrow. I mean, you have to pass some tests first, but you can go to law school tomorrow. But you have just such bright futures ahead of you. And I love to see, our next generation of civic leaders sitting in front of me on this little Zoom cube. But you're kind of sitting in front of me, and I'm just very proud of each and every one. You should be proud. Your teachers should be proud. Your parents should be proud. Everything is just very strong.
Thank you so much, and also thanks to the respondents team for being here and for having such a great argument. It was really a joy to listen to.
Thank you.
Oh, that's
Yes,
nice.
we'd
Yeah.
like to thank you as well.
Thank you. Anything else you want to ask? Anything from the coaches? Go ahead, Dan.
Yeah, it's kind of just a more sadder question, but do you ever feel miserable as being a lawyer?
That's a good question. Well, look, I'll be honest. I tell my students this: attorneys have a very high rate of depression. That's not a joke. Reed's chuckling, but you got to take care of yourself. This is a very stressful job, and you don't always get praise. See, we're giving you these very nice praises. You don't always get that. And it's very often the case that you might feel that you're not getting the reward that you deserve. I don't know, Reed, you want to say anything about this?
Absolutely. I mean, I know plenty of classmates who struggle with issues. And I know Ashley's probably and it's kind of a common bond amongst law students. I assume lawyers and law students both, because I talk to practicing attorneys all the time. Just talking about, oh, I'm so tired. My boss is writing me, a partner who doesn't thank me, and you're doing work constantly. But You got to take care of yourself. You got to go for a walk. You have to exercise, spend time with your family. You got to get away from it because if you don't, you'll feel miserable. But no, I mean, everyone feels miserable at some point, right? Even so, I guess the answer to that is yes, but it's not the end of the world.
Yeah, Ashley, you're in the mix of it. What do you think?
I think exactly what Reed was saying. It's all about balance. You know, your first year of law school, it's kind of shock. I mean, before law school, I talked to any attorney. I'm like, yeah, I really want to go to law school. Like, do you have any advice? And they're like, don't go to law school. And it's like a joke at first, but now you kind of feel it. But I mean, I think it's just all about balance. You know, your first year, first semester, you don't really know how to balance. And then it gets easier. And I'm assuming as a practicing lawyer too, like once you go into a firm, you just figure it out and it gets easier and you figure
Yeah,
out the work-life balance. I'm not really sure I'm at that point yet, but
yeah. Don't be afraid to ask for help. That's another thing that's no matter what you do. There are people around you who care about you and want you to succeed. Even professors like me who make your life miserable actually do care about you. We're doing this not because we want to torture you, but we want you to grow and be stronger from it, right? The sorts of really hard questions that I'm asking you are not designed to make you look weak, but to find in yourself the strength to actually persevere and to level up. I'd much rather you struggle in this fake virtual Supreme Court competition than when you actually go to a real court. I mean, that's why I make law school so difficult. I'd rather you mess up in my class in front of a judge. Because you mess up in my class, I'll say, okay, whatever. All right, it's Tuesday, tomorrow's Wednesday, right? But if you mess up in front of a real court, well, there's a client, right? And there's money involved, and then there's a partner. So the sort of stressful environment of law school in many ways is designed to prepare you for what comes next. But Reed, Ashley are very well spoken. They said the right thing. Take care of yourself and ask for help. But you know, I think managing yourself and manage your expectations and know what you're getting yourself into. Not everyone has worked for a big law firm, right? Not everyone works 90 hours a week. There are other types of law you can do. You can have part-time, right? You can work public interest. You can do nonprofit work, right? You can do various things that aren't billing 95 hours a week that you never see your mom and dad and husband and wife and brother and sister. So, you know, as the book goes, you choose your own adventure, right? You choose which path you pick with eyes wide open. And if nothing else, this competition gave you a 15-minute preview of what those eyes open are, right? You got a 15-minute preview of what law school is gonna be like. Because I didn't hold back. I gave you the same business I give a first-year law student. Reed and Ashley will attest that the same business I give my students, I gave to you. So now you know what it's like. And now I smile afterwards and say, good job, well done. But thanks, Dan. That's pretty, it's a very mature question. Thank you.
Do you have any advice for when you're in law school? How do you really balance? As I think, Ashley, you were talking about, it's all about finding that balance. Any advice on that?
I'll ask Reed and Ashley to go, whoever wants to answer. You guys are closer than me.
I think it just comes with time. You know, it's not going to happen your first week, or probably definitely not your first month of law school. I feel like just the first semester, you're just trying to figure out, one, how do you read and brief cases, and two, how do you prepare for class where you feel adequate to answer the questions, and then finals come in. But I think it's just, you know, getting familiar with the environment, and then you'll figure it out. And then trying to pick, I guess, what time around your schedule, like when can I go walk my dog, or when can I go to the grocery store? Just like trying to find things to break up your day where you're not just at the school and reading. And I don't know if that helps, but I think you're just getting in a schedule and just trying to find the gaps and making them most valuable to you.
Yeah, I mean, do you know how a diamond's made?
Under a lot of pressure.
Yeah. So I mean, look, you're just gonna adjust. Like you're gonna get more efficient at it. You're learning how to read cases. At first, it took me like 2 hours to read like a 5-page case, and now I can read it much faster. I can't tell you time estimates now, but I'm much quicker at that. And you learn how. And I was much more inefficient at studying for finals, where before I had to start studying way super far out. Now I'm like, oh, I know how a law school exam works. Maybe I can only study for a month as opposed to 2 months out, or what have you. You just become more efficient at what you're doing, and that will let you have a little more free time. You see what I'm saying?
Yes, yes.
Yeah, scheduling becomes so important because you have class a certain number of hours a day, and then every class has reading, and you might have 100 pages of reading a week, which might not sound like a lot, but Reed's saying it took him 2 hours to read 5 pages. You can do the math. That's 40, 50 hours of reading a week on top of being in class, 15 to 20 hours a week. And then after you say, well, when do I sleep, right? When do I eat? When do I see my mom, right? When do I go home, see my parents? And then after a while you say, I can't work anymore. And the stress kicks in. So you need to be very careful with your budgeting. And of course, you get better with time. I think Ashley made that point quite well. You get to read faster, but the first month or maybe the first semester even, I was an evening student my first year of law school. I was working 40-hour week job my first year of law school. So I basically was at work from about 8:30 till 5. I left work, had maybe half an hour break, and went to school from at 6 till 9:30. And then I got home, studied a little bit, got up in the morning, did it all over again. And almost all of my studying would happen on the weekend. So basically from when I woke up to went to sleep on Saturday and Sunday, I was studying. So it was basically a marathon run at a sprint pace. You're basically sprinting for the entire semester. And then you have finals, which is a nonstop program. I'd take leave for basically 2 weeks. It was stressful. But you find the balance that works for you, and maybe it's not the right balance. You try it again differently. But these are very mature questions. I appreciate what you're asking me. I wasn't expecting to give this spiel, but I'm grateful. In the last bit of the day, we have usually questions. What should I major in? Right? These are actually more actually, I think, more significant questions.
If I can do it, you all can do it.
Yeah, no, these are both reading, actually both in my class. They're both excellent students, top of their class. And again, I'm dragging them here at 5:30 p.m. on a Sunday. So I'm grateful they're still doing this.
No, it's daunting and it's scary, but it's so doable. And I know if y'all want to do it, then you definitely can do it, and y'all will be great.
Other questions you have? Feel free to pick away. Garrett or Bryce, anything you want to add? It's a slog for this day, but I'm always happy the coaches that are here.
Appreciate you guys giving up your weekend for this.
It's my pleasure. If I got through to one of you, I think it'll be worth it. All right.
Yeah, no, just thank you guys so much.
All right. Thank you, sir. And with that, I think we'll say goodbye to the students, and the judge will talk for a few minutes. And we'll be posting the scores tomorrow. So thank you so much.
Thank you so much for doing this and running the competition.
Thank you. My pleasure. Have a great day, guys.
Thank you. Have a good evening.
Thank you. All right. Let me stop the recording.